Welcome. It's Michael Gullo and my partner, Christina Carollo,
Welcome.
Gullo and Associates, and welcome to the foundations of the DJ action. The DJ action is a declaratory judgment action which we commence in Supreme Court with the carrier as the plaintiff, where we ask the Supreme Court to declare that basically there's no duty to pay, defend, or indemnify on certain claims related to the policy. Basically, at the end of the day, it's used to eliminate the future obligations on the claim, whether they're pending in AAA arbitration, litigation, or not even filed yet. Why file the DJ? Efficiency. It provides a defense of multiple claims and lawsuits in one shot, meaning once we get a determination in the DJ action, that will apply to our AAA actions and it will apply to our civil court actions. The Supreme Court judgment will have a binding effect on arbitrations and civil court actions. And it gives us a bit of control. Christina, I know in these summonses complaints that you draft, you usually like to choose the venue as the first department, New York County. Is that true?
Yes, we were doing that most frequently when IME no-show was one of the common issues in a DJ action because we wanted them to follow the Unitrin case, which held that the denial is effective retroactively
Right.
from the date of accident. So it was a great decision, and the
Yes.
first department followed it. So yes, and you know what, they expedite their cases more quickly. I like that venue. I think I still do currently.
Right. And it's effective against high volume or repeat providers claims. You see those providers and they file multiple low level, low dollar amount lawsuits just to jam you up. And this is a very effective way to deal with that. It's funny, Christine. I was asking you a question. I was like, "Is that true?" Like, come in, like, cross-examining, doing a deposition. Would you
It's
agree with that
okay. You had
statement?
your lawyer on. You had your lawyer on for a
Can't help
second.
myself. All right. The legal requirements for a DJ. It has to be a judiciable controversy, meaning that it actually needs to be a legitimate claim or controversy. And we recite the policy terms and we give the specifics, the vehicles involved, the dates of the policy violations, of the denials, and fraud, which we'll get into, that we give the specifics because that has to be pled with particularity and a list of related claims that are being denied. So we put everything, all the legal requirements for the DJ. Basically, our proof is what we would use for a summary judgment motion, right? I mean, we
Yeah.
go pretty deep.
And it needs to be detailed, because you want to use this decision. And even the decision's usually drafted very detailed because we want to use this decision to effectively dismiss all the lower court action should
Yes.
we prevail. So you want that claim number in there, you want all the assigners in there, et cetera, et cetera. So yes, you want to be very detailed and particular.
And we want certified policy. We want that, a copy of the certified policy, the
You
IME,
need that.
the letters, no-show affidavits, denials, claims examiner affidavit, just like we would on a summary judgment motion, not necessarily saying that all the denials are timely, but at least letting us know that the general denial went out. Fraud or SIU reports, any EO transcripts that were relied upon if it's a fraud case or statements. Basically, the proof that we relied on the fraud, we want to have that all ready to go for our motion practice.
Yep, I see you. I see it says in affidavit form, we have to ensure that they're all admissible in court when moving for that DJ.
Admissible proof always, yes.
Yes.
So before we file, a claim gets analyzed. Are there pending claims or is there high exposure likely to have a number of claims? Do we have the clear violations that we're talking about, the EUO no-show, the IME no-show, or a fraud? And do we have that necessary proof? It needs to be perfect. We want denials, general denials going out. So if it's not, and we don't have this perfect file, then we consider defending the individual bills. But in the most part, by the time we get to this stage, we do have a perfect file, especially if we handled the EUO. That brings us to our next section, which is section 2. Get my screen together here. There we go. So section 2 is filing and procedures of the DJ action, the mechanics behind it, how it's filed, summons and complaint service, responses, motion practice, and basically tracking it from the initiation to the decision stage. Drafting and filing the summons and complaint. I know, Christina, you enjoy drafting pleadings.
I do, especially 125-page documents. Yes.
These
With the
complaints
DJ
do,
action, we do have to repeatedly reiterate all the allegations against every single party, and it's usually what, 15 to 20 or not more.
yeah, the paragraphs can be quite lengthy in the complaint, the DJ complaint, because we clearly state the relief, we cite policy, the provisions, we detail the facts, the date of the accident, the claim info, the reason for the denial. We list all of the known parties, which is all providers that are known at that time. And that also includes our claimants and the insured. If they, of course, are the claimant who violated the policy. Once we draft the summons and complaint, service of process, we must serve all of the defendants. If it's a provider, we generally go through the Secretary of State. We found that to be more effective and it's more of a sure service. If they're individuals or claimants, we will do that through the regular CPLR personal service using a process server. And I know sometimes this can delay, right, Christine? We have 120 days to serve, but we try to get that done, within 30 to 60 days, as quick as possible.
We started as quick as possible, yes, because a lot of these assigners are hard to reach, and what happens is they'll have to eventually nail and mail, and that takes sometimes over a month for the process server to
Yeah.
actually get to that point of doing their multiple attempts and then nail and mailing it. So sure. And even with the Secretary of State, there are times where we can't locate the actual provider's name because so many different providers go by so many different names on the bills.
Yeah.
And then if we don't find the Secretary of State document showing that they're an actual corporation, we will have to personally serve them as well. So
Right.
it's definitely a long process.
Right. When the carrier prepares the file to send down to us as the attorney for the DJ action, providing us with as much information as you can, maybe a bills, if you have any bills, just so we can get the name and address of the provider, or their TIN numbers if you have them,
A
the proper
W-9 is
names.
beautiful.
I mean, these are all helpful because then our job, what we do on our end is we jump onto the New York State website of corporate for corporations. We double check to make sure to see that they're an existing corporation before we send it off to Albany to be served upon the Secretary of State so that we know we're serving the right party.
Yes.
Answers, defaults, and motions must answer the standard 20 days, 30 days. We monitor for defaults. What we do generally on our end is we do send, if we have a service of process, we wait the 30 days. If we get no response, we send a follow-up letter asking them to please respond. You're in default. We will be making a default motion. Once they don't respond to that letter, generally about 30 days, then it becomes time for us to draft our default motion. If
Yes,
there
and
are,
timing is important because you have a year to file that default motion.
right, you have two, yes, you have two, but we're quick. I mean, we do it as expedited as
Of
possible.
course, but it's within a year after the default, of course. So, timing is always everything with these cases. I just want to make a point for anyone who's watching.
Absolutely. We anticipate counterclaims, motions to dismiss. I'd say that they're rare because if our documents are accurate and we draft our complaint the right way, like a summary judgment motion, basically, most of the time, providers don't want to get involved because they know they're going to lose at the end of the day. So part two to this is, again, if they don't appear, a little bit more detail on what our best practices generally are. So we do send the follow-up because sometimes the courts, especially with these claimants, it's supposed to be non-adversarial, and the courts try to give them every opportunity that they can to appear, and they want to make sure these people knew about it. So in addition to the affidavit of service, we have our follow-up letters, and we had due diligence in trying to locate them before we applied for the default. If there are parties that answer, or if there's motion practice, we can wind up in court. We generally will at some point. If there are parties that answered, before our summary judgment motion, we may wind up at a preliminary conference or some type of a compliance conference. But our motion for summary judgment, especially on the policy violations, I'm going to exclude fraud. That's a little more complicated. But on the clear things like EUO no-show, IME no-show, those policy violations, we should win on summary judgment. And those summary judgment motions will go out fairly quickly because there is no discovery that shouldn't be needed to be exchanged.
Yeah. So the next process is a summary judgment motion. Yes.
That concludes our section here. I want to move along, keep us rolling. Now we come to the section is our DJ decision, or we have our default motion done. We have a summons and complaint completed. We have that served, sent out our letters. Nobody responded. We have a default motion, or we have a motion for summary judgment. And I also wanted to add from the prior section that there is a motion that can be made if there's some time gap and it's taking a little bit longer than anticipated. We can make a motion in the Supreme Court to stay the lower court arbitration and civil court actions pending the DJ action, which should resolve all of those matters. And generally, I don't think we've had one of those denied just yet.
No, but
So,
you make a great point because there are times when our DJ action is still pending and we have a trial coming up in a lower court case, and the court always asks you, is there a decision staying lower court actions? And some judges will continue to adjourn it and others will force us to go forward. And that motion is really important.
So the DJ decision, the court's ruling on a DJ action coverage and the implications of that and how they're framed, they're read, and we're going to go through, I believe I have a wherefore clause in here as well. Nope, there's the wherefore clause. So basically, this is what we're asking for in our relief. We're asking for a declaratory judgment that has no obligation to pay pending or future claims for no fault benefits, bodily injury, uninsured, underinsured motorist benefits. Also, no obligation to defend or indemnify. One, an order permanently enjoining all of the defendants from initiating or prosecuting any actions for costs, which we generally do not get, and for any other further relief, which is standard. So once we get this order and the judge issues that order is then presented, and we say, here's an order from the court. We have no obligation to defend, indemnify, or pay any claims, so they get dismissed at the AAA and civil court level.
Yeah, I mean, some attorneys won't just immediately dismiss it. And if that's the case, I don't know if your next slide talks about it, but we'd have to make our motions to dismiss or summary judgment based upon collateral estoppel, res judicata, and whatever else we need to move based
Right.
upon that order.
Right. So the court basically issues a declaratory judgment clarifying the coverage obligations, can be in the default order or summary judgment order, granting summary judgment to the insurer, and the ruling becomes binding unless overturned on appeal, which I don't think we've had a DJ action appealed to date.
Bite your tongue.
Oh, I said up until this morning, so right now, as of my last email check, we're good. The effect on the underlying no-fault cases, again, it's binding. Future arbitration, even on future litigation and arbitrations, once we get those in, it can be a pre-answer motion to dismiss at that stage or a summary judgment motion immediately. Denials based on the D-Day decision. Once we get the DJ decision in and you get new claims in, and we need to issue new denials on those claims, we can reference the DJ decision, say, based upon the Supreme Court ruling, you're not entitled to benefits, and that DJ decision will get attached to your denial, and that'll go out as your denial. And arbitrators and judges, they see these and they know what they are and that they are applicable, and they respect them, usually without too much trouble.
And, just to reiterate, we don't always have to make that motion. We could really just be like, we have a DJ decision. Here it is, stipulation of discontinuance. It could be that easy for the lower court case to be completed and disposed of.
Yeah, we do often also see a lot of defendants, once the DJ is served, they'll look at it and they will just voluntarily withdraw all of their claims because they don't want to deal with it because they know that they're losers.
Right, defendants, you mean the providers that would be in a
Correct.
plaintiff in a lower court action, but yes,
The
they'll send
defendant
out a general release.
providers.
Uh-huh.
Correct, because we're
They'll
the
send out a
plaintiff
general
here.
release.
So the common outcomes again is the IME and the UO non-cooperation, no coverage obligation, material misreps, the policy's void, other defenses, denials affirmed, fraud, things of that nature. The enforcement and next steps, basically, we take the DJ decision, we use it as an exhibit, and we present it to other judges in our motions and at arbitration. And we want to make sure, of course, that it's properly entered. So we get that decision, we enter it with a notice of entry so that it is valid. Bringing us to our next section, final section. Strategic use and best practices, practical guides for using. How do we use it to reduce risk and exposure? Basically, before claims payments are made, we can have the DJ action going. We can have it simultaneously. Usually by this time, there has been a couple, can be up to I don't know, usually 2 to 3 months, you'd say, Christina, before the policy violations on the fraud investigations are completed. The IMEs are no-showed, the EUOs are no-showed.
Sounds about accurate, yes.
So by that time, we are going to have a good list of providers. Once we're gathering the DJ information, it'll take a little bit of time. So, by the time we're pretty well into the treatment of this person, we'll have a good idea of who all of the providers are. So when verification responses indicate a strong defense, that is, we have all of the documents and we have all of our ducks in a row, basically. I know we went over that earlier, but it's important. So to go over it 2, 3 times is probably a good idea. Early in the claim cycle, because once we establish that we have no duty to pay, this will carry over to our future. So once that happens and they continue to treat with these providers, it reduces our exposure moving forward because we know that this judgment's going to be binding.
Yeah, and you also want to start it early on because there will be cases that start to be filed in both arbitration and lower court. And we want this decision before, so that we could then dispose of those cases. So yes, we can make a motion to stay, but to avoid those additional steps, it would definitely be smart to begin it early. And if there are a few stragglers, providers like maybe a surgical company because they had surgery 6, 7 months after treatment, pharmaceutical companies, I'm sure that's not going to be many bills or providers, and we could always just take care of that separately. Sometimes you could show them just by issue preclusion. You're not named in the DJ, but this is what we're moving for. The court's already determined on this issue.
Right,
Will you dispose of it? And sometimes
right.
they'll do that also, even if
Yes.
not named in the action.
And sometimes we do get plaintiffs' attorneys. I know we all know who they are, but some plaintiffs' attorneys plaintiffs meaning the defendants in this action, the attorneys for the providers, right? They will contest it. They will start wanting to ask more questions, and they'll possibly want depositions, which we're not afraid of. If they want to go that route, that's fine. Our stuff is pretty tight. But that does open the door to good resolutions and settlements across the board for both them and us. So when the DJ actions, what part of our goal is to not have inconsistent decisions. It happens a lot, especially in arbitration and civil court. You'll have different venues, different judges, and different arbitrators ruling different ways on the same set of facts, and it's all over the place. So this kind of limits that inconsistency so that we get one ruling across the board. I mean, you
Yep.
see that a lot, Christina, right? Where you're like, it's the same case.
Absolutely. You see that a lot in fraud cases. You also see that a lot, not as often now. I feel like everyone follows Unitrin and Fogel, but even with IME no-show, you see that commonly because
Yeah,
there's two conflicting departments.
right.
So yes. So to put it in the first department and to get a binding decision on all lower court actions and arbitrations is key when it comes to that.
Right. And this is, again, we were just talking about including, copies of the denial of the decision and the denials, leverage and settlement negotiations, because it can make it a fair resolution on both sides of the fence, a win-win, notifying providers of the judgment and its implications. And we, of course, submit them to the arbitration, AAA, and to the civil courts. Some practical tips, reiterating proper service is important. Without proper service and affidavits of service, it collapses. So we need that. That's key. Relevant providers, want to have the providers in there with their proper names and addresses and the DJ action complaint named as defendants. We watch for oppositions, default timeliness, keeping our eye on those things, and we keep everything organized so that if it goes further down the road, we have all of our documents and exhibits organized and ready to roll. Anything you want to add, Christine? I think we did a good overview of just the procedural process. We're not giving away any proprietary information on the internal workings or how that
Yep.
happens. This is just if anyone's filing a DJ, this is the basic procedures that they'll follow.
Yep, I think we covered all ends. I think we did a great job, Michael.
All right, well then, thank you for joining us.
Well, thank you.
Have a great day, and I'm sure we'll be talking
Everyone.
later. Bye-bye.